attorneys to dispense with opening arguments in this case. However, I do know that there were some changes in the posture of some of the claims that were made, and I would like the attorneys to, first of all, state your appearances on the record, and then if you would, for the plaintiff to go over the causes of action that you're going forward, just name them. Don't need to argue them. I've heard a good bit of argument on those already. And then when we get to the defense, I'd like to also know what counterclaims you're still going forward on so that we've got a clear understanding as to what issues are being presented before the court during these hearings. So I'll give you a second to take a look at that. I'd ask you to dispense with opening arguments, but I think since we did have that change in the posture of the case, that we ought to be clear about what we're going forward on.
Your Honor, Troy Tessier for the plaintiff, Anderson County, joined by Ted Gentry, Tally Parham, also from the White's firm.
Good morning.
All representing Anderson County. We also have Tom Allen, who's the chair of Anderson County Council, as our client representative.
Good morning, sir.
And just to try to answer your question, Your Honor, the plaintiff's claims, I believe, are all going forward. Let me find my amended complaint.
I listed some 11 of them on the notes that I took, and maybe I should go over with you what I have, if you disagree with what I have that you're alleging an ethics code violation concerning the contract.
Yes, sir.
That it's void as a matter of public policy is the second one. That Mr. Preston violated the state and local ethics code. That Mr. Preston committed fraud. That Mr. Preston committed constructive fraud. Preston committed a negligent misrepresentation, that the actions of counsel constituted actions that were arbitrary and capricious, that Preston breached the contract, that Preston breached fiduciary duties, that the retirement system should refund monies paid to it, and that Mr. Preston has been unjustly enriched.
That's correct, sir.
Have I correctly stated the actions that you're still going forward on?
Yes, sir.
Okay. Any others?
No, sir.
Thank you. All right, for the defense.
Good morning, Your Honor. Lane Davis and Ken Kern-Fuller.
Good to see both of you again. Yes.
Defendant Joey Preston. I believe that some communications with the court have occurred with respect to our tort-based counterclaims. We have reached a settlement, and those claims won't be part of the case. However, that does not impact our contract-based counterclaim arising out of the severance agreement, and specifically with respect to paragraph 8. In the case, there has been a limitation with respect to the damages that we're claiming. That limitation is that we are going to be pursuing basically the defense costs and defense fees arising out of the breach of the covenant not to sue in the severance agreement. All of the income-based claims and
I'm sorry, the what based claims?
the lost income-based claims.
Income-based claims, all right.
And also all of the
I just didn't get that word. Go ahead.
all the reputational-based claims were racked up in the settlement that occurred.
So that's all out.
It's all out.
Okay.
And as a consequence of that, Your Honor, I think you may recall we had a limiting motion, and part of the reason why the court didn't rule upon that limiting motion was because of the reputational element of the damages. Well, all of that has been removed from the case.
Okay.
As a consequence, I'm hereby renewing our motion in limiting with respect to all those grounds, and ask the court that it limit the scope of this case, because I believe that that will greatly simplify this before Your Honor.
All right, let's hear from the plaintiff concerning that particular issue.
One point, Your Honor, we agree with most of what Mr. Davis said about the counterclaims. The tort-based counterclaims have been removed. As Your Honor knows, you did sign a consent order as well, which strikes from the pleadings certain paragraphs of the breach of contract claim, which then focuses the damages there.
Mm-hmm.
We think it's still, Your Honor, premature to rule on the motion in limine, and really believe the court needs to hear some context and then decide for certain what should stay or not stay in the case. I don't want to re-argue the entire thing unless the court...
Well, I don't want you to re-argue it either. I will, and I won't rule on that at this time, but I will tell you that, as Mr. Davis has said, if the tort-based counterclaims have been resolved, then the degree to which we would go into those matters, I think, would be somewhat limited. I'll just tell you that before we get there.
Yes, sir, and I think our position is going to be that there will be a distinction between reputational injury type claims and, for example, credibility, which will be an issue in this case regardless.
Well, again, I don't know where that'll lead, where that's going to lead us, so I will reserve my rulings in that regard. Yes, sir.
Your Honor, one more preliminary motion. At this time, the defense would move to sequester the witnesses.
Any objection to that from this plaintiff?
No, Your Honor.
Well, before I make that order, are there particular individuals that you think should remain in the courtroom to assist you with your case, the presentation of your case, that may also be a witness in the case?
No, Your Honor.
My understanding of the rule, Your Honor, is that primarily applies to expert witnesses, and if we don't have our expert witness here, I don't think we need him. If we choose to try to have him present at some point, we'll let you know.
I think the sequestration order will apply to anyone who you intend to present as a witness in the case.
And one last point on that, Your Honor, we do have Tom Allen is our client representative here. He is likely to be a witness, I think.
That's what I was referring to. Is there somebody that you want to keep
Yes,
in
sir.
the courtroom that would be of assistance during the trial?
Yes, sir.
Okay, he's named Mr. Allen.
Well, yes, Your Honor, we would object to that. I mean, obviously, Mr. Allen is only one of 7 council members. And in addition to that, the county attorney is sitting right behind him. And, in addition to that, you know, he's under subpoena. And in this case, Your Honor, we think that one of the most critical things that you're going to hear by way of evidence is that there's going to be, let's say, contrasting evidence from witness to witness about identical issues. And obviously, there is some danger with respect to the defense in this case if the witnesses are allowed to remain and
well, what they're asking for, though, is just for one person to remain who is considered to be their client.
yes, Your Honor. Out of the county council members, however, I think I have Mr. Allen under subpoena, and I have Ms. Wilson under subpoena.
Well, I'm going to let them designate one. And so whoever that is, I'll let them have one.
Okay.
All right, so, and that is Mr. Allen.
Yes, sir.
And I assume obviously Mr. Preston's party, and I'll allow him to stay as well. All right, I then will grant the motion for sequestration of witnesses. If there's anyone in the courtroom who is a potential witness in this case, I'll be asking that you leave the courtroom at this time. I will caution those who would be involved in this not to discuss your testimony or possible testimony with anyone. As long as the trial is proceeding, that order will remain in effect whether you have testified yet or have not testified yet. Good morning. How's everyone this morning?
Good morning, Your Honor.
Gentry, Mr. Davis, Mr. Colonel Furley, Ms. Tessier, how are you doing today? All right, I'd asked the attorneys to dispense with opening arguments in this case. However, I do know that there were some changes in the posture of some of the claims that were made, and I would like the attorneys to, first of all, state your appearances on the record, and then if you would, for the plaintiff to go over the causes of action that you're going forward, just name them. Don't need to argue them. I've heard a good bit of argument on those already. And then when we get to the defense, I'd like to also know what counterclaims you're still going forward on so that we've got a clear understanding as to what issues are being presented before the court during these hearings. So I'll give you a second to take a look at that. I'd ask you to dispense with opening arguments, but I think since we did have that change in the posture of the case, that we ought to be clear about what we're going forward on.
Your Honor, Troy Tessier for the plaintiff,
Yes.
Anderson County, joined by Ted Gentry, Tally Parham, also from the White's firm,
Good morning.
all representing Anderson County. We also have Tom Allen, who's the chair of Anderson County Council, as our
Good morning.
client representative.
Good to see you, sir.
And just to try to answer your question, Your Honor, the plaintiff's claims, I believe, are all going forward. Let me find my amended complaint.
I listed some 11 of them on the notes that I took, and maybe I should go over with you what I have, if you disagree with what I have that you're alleging an ethics code violation concerning the contract.
Yes, sir.
That it's void as a matter of public policy is the second one. That Mr. Preston violated the state and local ethics code. That Mr. Preston committed fraud. That Mr. Preston committed constructive fraud. That Mr. Preston committed a negligent misrepresentation. That the actions of counsel constituted actions that were arbitrary and capricious. That Preston breached the contract. That Preston breached fiduciary duties. That the retirement system should refund monies paid to it. And that Mr. Preston has been unjustly enriched.
That's correct, sir.
Have I correctly stated the actions that you're still going forward on?
Yes, sir.
Okay, any others?
No, sir.
Thank you. All right, for the defense.
Good morning, Your Honor. Lane Davis, and Kern Fuller.
Good to see both of you again. Yes.
Defendant Joey Preston. I believe that some communications with the court have occurred with respect to our tort-based counterclaims. We have reached a settlement, and those claims won't be part of the case. However, that does not impact our contract-based counterclaim arising out of the severance agreement, and specifically with respect to paragraph 8. In the case, there has been a limitation with respect to the damages that we're claiming. That limitation is that we are going to be pursuing basically the defense costs and defense fees arising out of breach of the covenant not to sue in the severance agreement. All of the income-based claims and
I'm sorry, the what based claims?
the lost income-based claims.
Income-based claims, all right. Excuse
And
me.
also all of the
I just didn't catch that word. Go ahead.
all the reputational-based claims were wrapped up in the settlement that occurred.
So that's all out there.
It's all out.
Okay.
And as a consequence of that, Your Honor, I think you may recall we had a limiting motion, and part of the reason why the court did rule upon that limiting motion was because of the reputational element of the damages. Well, all of that has been removed from the case.
Okay.
As a consequence, I'm hereby renewing our motion and limiting with respect to all those grounds, and ask the court that it limit the scope of this case, because I believe that that will greatly simplify what's before Your Honor.
All right, let's hear from the plaintiff concerning that particular issue.
One point, Your Honor, we agree with most of what Mr. Davis said about the counterclaims. The tort-based counterclaims have been removed. As Your Honor knows, you did sign a consent order as well, which strikes from the pleadings certain paragraphs of the breach of contract claim, which then focuses the damages there.
Mm-hmm.
We think it's still, Your Honor, premature to rule on the motion in limine, and really believe the court needs to hear some context and decide for certain what should stay or not stay in the case. I don't want to re-argue the entire thing unless the court...
Well, I don't want you to re-argue it either. I will, and I won't move on that at this time, but I will tell you that, as Mr. Davis has said, if the tort-based counterclaims have been resolved, then the degree to which we would go into those matters, I think, would be somewhat limited. I'll just tell you that before we get there.
Yes, sir, and I think our position is going to be that there will be a distinction between reputational injury type claims and, for example, credibility, which will be an issue in this case regardless.
Well, again, I don't know where that'll lead, where that's going to lead us, so I will reserve my rulings in that regard. Yes, sir.
Your Honor, one more preliminary motion. At this time, the defense would move to sequester the witnesses.
Any objection to that from this plaintiff?
No, Your Honor.
Well, before I make that order, are there particular individuals that you think should remain in the courtroom to assist you with your case, the presentation of your case, that may also be a witness in the case?
No, Your Honor.
My understanding of the rule, Your Honor, is that primarily applies to expert witnesses, and if we don't have our expert witness here, don't think we need him. If we choose to try to have him present at some point, we'll let you know.
I think the sequestration order will apply to anyone who you intend to present as a witness in the case.
And one last point on that, Your Honor, we do have Tom Allen is our client representative here. He is likely to be a witness, I think.
That's what I was referring to. Is there
Okay.
somebody that you want to keep
Yes,
in
sir.
the courtroom that would be of assistance during the trial?
Yes, sir.
Okay, he's named Mr. Allen.
Well, yes, Your Honor, we would object to that. I mean, obviously, Mr. Allen is only one of 7 council members. And in addition to that, the county attorney is sitting right behind him. And in addition to that, he's under subpoena. And in this case, Your Honor, we think that one of the most critical things that you're going to hear by way of evidence is that there's going to be, let's say, contrasting evidence from witness to witness about identical issues. And obviously, there is some danger with respect to the defense in this case if the witnesses are allowed to remain and
Well, what they're asking for, though, is just for one person to remain who is considered to be their client.
yes, Your Honor. Out of the county council members, however, I think I have Mr. Allen under subpoena, and I have Ms. Wilson under subpoena.
Well, I'm going to let them designate one. And so whoever that is, I'll let them have one.
Okay.
All right, so, and that is Mr. Allen.
Yes, sir.
And I assume obviously Mr. Preston's party, and I'll allow him to stay as well. All right, I then will draft the motion for sequestration of witnesses. If there's anyone in the courtroom who is a potential witness in this case, I'll be asking that you leave the courtroom at this time. I will caution those who would be involved in this not to discuss your testimony or possible testimony with anyone. As long as the trial is proceeding, that order will remain in effect whether you have testified yet or have not testified yet. All right. Plaintiff ready to call the first witness?
Yes, Your Honor.
You may do so.
Your Honor, Anderson County calls Bob Waldrep to the stand.
Waldrep, come forward.
Raise your right hand, please. You solemnly swear affirm the testimony you give the court today in this case to be the truth, the whole truth, and nothing but the truth?
I do.
If you would take a witness stand and state your name for the record and spell your last name, please, sir.
My name is Robert Waldrep, W-A-L-D-R-E-P.
That's your witness.
Thank you, Your Honor.
Yes, sir.
Good morning, Mr. Waldrep.
Good morning.
Would you tell us, please, where you currently reside?
I reside at 2703 Jackson Square, Anderson, South Carolina.
And how long have you lived in Anderson County?
In Anderson County since 1964.
Where did you go to school, college?
I went to the University of South Carolina.
And after did you graduate?
I did.
What did you do after graduation?
I went to the United States Navy for 2 years.
And what did you do in the Navy?
I was a journalist and a radar man.
What years did you serve in the Navy?
Beg pardon?
What years did you serve in the Navy?
That would have been 1959, 1960, I believe.
Did you receive an honorable discharge?
I did.
Thank you, Mr. Walker, for your service. What did you do after you left the Navy?
I applied to law school at the University of South Carolina and was accepted and finished law school in about 1964.
Did you pass a bar exam after you graduated?
I did.
Where did you pass the bar?
In South Carolina, Columbia.
Have you been licensed to practice law in South Carolina since you passed the bar?
I have since 1964.
How would do you have a law practice today?
I do.
How would you describe your law practice?
It's a general law practice. My daughter and I practice together right across the street from the courthouse.
Have you ever served on the Anderson County Council?
I have.
And when?
I believe my first service was something like 90 to 91 or 91 to 92, that era. I served one term.
And then what did you do after that term on the council?
I ran for the South Carolina State Senate.
Were you successful?
I was successful, and I served 3 terms. I served 12 years in the South Carolina Senate.
Did you have another opportunity at some later point to serve on the Anderson County Council?
Yes, I volunteered to leave the Senate, and then I ran for council, District 1.
And do you recall when that second period of service on the Anderson County Council occurred?
I'm trying to think, probably about 2004 to 2006, maybe.
You realize that part of this case deals with the administration of Joey Preston, is that?
I do.
Was Mr. Preston the county administrator when you served on council the second time you served?
Yes, he was.
And do you remember when you began your service, or do you remember when Mr. Preston left his service with the council, just to try to get you?
I believe he left in December of 2010, I think.
I can show you some documents in a minute.
Yes, right.
That might refresh your memory.
Okay.
When you started with Anderson County, after your service on the South Carolina Senate, was Joey Preston the county administrator?
Yes, he was.
And did you serve as the chair of county council when you started again with the Anderson County?
That's right. My first year, I was elected chair of county council.
And how did your service on Anderson County Council come to an end?
I served that term, then I ran for re-election, and after I served for about 18 months. They're 2-year terms, and after I served about 18 months, I was requested to be a trustee. I was at Orangeburg, South Carolina State, and I found out that there was a conflict there, and I could not serve both as a trustee of South Carolina State and as a county councilman. Didn't know that when I first started, but then at that point I resigned, and Francis Crowder succeeded me.
Do you recall what year that was? You may not, but
I'm trying. I thought that would be sometime in 2010.
Let me show you. Your Honor, may I approach the witness?
Yes, you may.
Find that. Mr. Waldrep, I'm going to hand you what's been pre-admitted as plaintiff's exhibit number 7. And I'm showing you this, Mr. Waldrep, to see if I can refresh your recollection as to when did you serve on the Anderson County Council before you started with South Carolina State. Do you recognize that document?
I do.
What is that document?
That's a severance agreement and release of claims for Mr. Joey Preston in the county, and it's dated the 18th of November 2008.
Okay, now does that help you
It does.
bring to mind when you served after your service with the South Carolina Senate? Does this help you remember when you served on Anderson County?
Yes, it does.
What do you remember about what your dates of service were roughly?
Well, Mr. Preston was to leave. I continued to stay on until I still thought it was December. Let's see. Mr. Preston stayed on until December the 31st, 2008.
And did you continue on
And
after?
so I thought it was maybe 2009, 2010, sometime when I stayed on, after Mr. Preston left.
Were you on the county council all of the year 2008?
Yes.
And was it your understanding that, or let me ask it this way, was Mr. Preston serving the county as county administrator pursuant to an employment agreement in 2008?
Yes, he pursuant to some kind of employment agreement. When I went on council, I had never seen his employment agreement until sometime later when some issues arose about his employment.
Okay. May I approach again, Your Honor?
Yes, you may.
Mr. Waldrep, I'm now going to hand you what's marked as plaintiff's exhibit number 1, and it's been pre-admitted.
Right.
And Your Honor, I'm hoping it's okay with the court, but at times we will present these documents on the screen, if that's all right. Mr. Waldrep, plaintiff exhibit number 1, can you identify what that is?
It's a master employment agreement dated 22nd of July, 1998 between the county and Mr. Joey R. Preston.
Is it your understanding that this is the employment contract that Mr. Preston was operating under in 2008?
Yes, sir.
If you would look at section 2A of that contract for us, and I'll present it on the screen
Right.
as well. Would you mind publishing to the court by reading that section 2A to us?
Right. It says term, section 2A. The administrator serves at the pleasure of counsel, and nothing in this agreement shall prevent, limit, or otherwise interfere with the right of the Anderson County Council to terminate the services of the administrator at any time, subject to the provisions set forth in section 3, paragraph A, B, and C of this agreement.
And now, Mr. Waldrep, if we look at section 3A of the agreement, which if you'll turn is on the next page. And I'm not going to ask you to read all this, Mr. Waldrep, because it's a little lengthier, but would you agree with me that that first provision is a provision concerning termination with cause?
Yes.
And if you look at section 3B, which is on that same page,
Okay.
is that a section of the contract that discusses termination of the county administrator without cause?
Yes, sir, it does.
So was it your understanding that the agreement that Mr. Preston was operating under provided for or allowed for the council to terminate him either with or without cause?
Yes, sir.
Do you have any understanding as to whether if the county council were to terminate Mr. Preston without cause in 2008, does it have to do anything with respect to Mr. Preston's contract if it made that choice?
Well, I'm saying that the council had the absolute choice to do it either way. But if it's without cause, then certain issues would come up about his severance.
And does the contract provide for a mechanism by which to calculate a severance payment to Mr. Preston?
It appears to provide a mechanism.
Mr. Walter, if you look at section 13 of the contract, which is on page 7 of the document in front of you, does the contract with Mr. Preston back in 2008 also have a provision concerning suspension of Mr. Preston?
Yes, it does.
And is this section 13 that's on the screen and on page 7 of Exhibit 1, is this the section that discusses how the county may go about suspending the administrator if it so chooses?
Yes, it does. If a majority of council votes to suspend the administrator, it has here for just cause, the administrator shall be given written notice and 10 days notice prior to a hearing and so forth.
So
Give him an opportunity to have a hearing if he desires one.
fair to say section 13 of the contract provides a process by which
That's
suspension
correct.
must occur.
Correct.
Do you know, Mr. Waldrep, just from your experience working for the state of South Carolina, do you know what state retirement service credit is?
Yes, sir.
What is it, generally speaking?
State retirement service credit is based upon the number of years and also the salary of the compensation that a person receives as a state employee.
And are you eligible for state retirement because of your service on the South Carolina Senate?
Yes, I am.
Are you aware or do you know whether or not a person who has state employment, do they have an opportunity if they wish to purchase state retirement credits on their own behalf?
They can.
Is there any provision in the contract that you're looking at, exhibit number 1, the contract with Mr. Preston that is there any provision in that contract that requires the county to purchase retirement service credit for Mr. Preston under any circumstances?
I'm not aware that the county would be required. I think the individual might have a right to, but not the county.
Now, Mr. Waldrep, if I may, I would like to talk to you about the year 2008, because we'll soon see, I suspect that it was a an interesting year for the county of Anderson.
Yes.
Does Anderson County Council operate with staggered terms for its council members?
No, it's just everyone runs at the same time for 2-year terms, all 7 council people.
So would it be fair to say that the entire Anderson County Council will be elected every 2 years?
That's correct.
Was 2008 an election year for the Anderson County Council?
I believe it was.
And who was on the council at the beginning of 2008 by name?
We had Mr. Michael Thompson, we had Larry Greer, Ron Wilson, Gracie Floyd, myself, Cindy Wilson, and Larry Greer. Did I say Larry Greer?
Yes. Mr. McAbee?
And Bill McAbee.
And perhaps for ease of reference, if you don't mind, Mr. Waldrep, I'd like to call that group of individuals the 2008 council. Is that fair?
That's fine.
Did every one of the members of the 2008 council run for re-election in 2008?
I believe everybody ran for re-election, if I'm aware. Yeah.
And did that include you?
That's correct.
When were the primary elections held in 2008? Do you recall?
You know, it was always a little bit fuzzy sometimes, but I believe that they were in June of that year.
And what is the significance of the primary election in Anderson County, in your mind?
Well, everyone was a Republican, as I recall, except Ms. Floyd. She was a Democrat. But the, I guess you might say, nomination by the party was tantamount to election at the general election. So if you were elected in your primary, and there was no opposition, you know, usually there might be a petition candidate or something like that. But basically, that meant you were going to be elected and you would be seated sometime in January, you know, the following January.
And the general election is held in November of every year?
That's correct.
What do you recall about the various platforms of the candidates that were running in the year 2008 for county council?
Well, it was a hotly contested election, and there were a lot of candidates put a lot of work into it. And the way the county was being run, and Mr. Preston was a big issue in that campaign. And
what
I
happened?
know,
Sorry, go ahead.
from what I know, several candidates mentioned Mr. Preston in their campaign literature as being interested in changing county council way of doing things.
So it sounds like some people were running on a platform that included concern about how the county was run up to that point?
That's correct. And interestingly enough, before this election in 2008, the same issue had come up, I think, in 2006. Mr. Preston was also an issue in that race as well.
Do you know which candidates in 2006 raised concerns or issues in their campaign literature about Mr. Preston back in 06?
I know that the chairman did, Michael Thompson, in particular, had indicated, I think, that he was not favorable to Mr. Preston. And then there were some others, let's see, who else? I just know that a couple other candidates did, you know, but I don't think that I got too much involved in that. I may have had an opinion, but I was not, in the prior election, I was not focused on Mr. Preston.
And what about in 2008? What happened at the actual primaries in 2008 in terms of who won and who lost?
In 2008, Mr. Allen, who's chairman now, replaced Mr. McAbee. And when I go back to my memory serves me correctly, Mr. McAbee was one of those who appeared to question Mr. Preston, you know, in his campaign literature kind of around that.
In 2006, you mean?
2006, but not 2008, because when Mr. Allen ran, I think people came to Mr. Allen, my understanding, and they wanted to know how the money was being spent in the county. So that was a change. Then Mr. Greer lost his seat to Mr. Moore, who had been questioning the county administrator and the way that the county was being run. And then Mr. Dunn replaced Mr. Thompson, who had done a 180-degree turn from 2006 to, he became a very strong proponent of Mr. Preston, and so Mr. Dunn was elected to replace Mr. Thompson. So that created, again, the word sea change in the politics.
So how would you describe the sea change as a result of the primary election results? How would you describe that sea change in terms of the level of support for Mr. Preston?
It was eroding quickly.
And would it be fair to say that the three you just mentioned who succeeded in the primaries, Tommy Dunn, Tom Allen, and Eddie Moore, appeared all to run on campaign platforms that were more questioning, perhaps, of Mr. Preston's administration?
That's my belief. That was my perception. Of course, I was running my own race, and didn't, I wasn't closely following their election, but that was my general impression.
And it sounds like 2008 wasn't the first time that candidates for county council ran on platforms that at least asked questions about the administrator's service. Is that fair?
Mr. Thompson, the previous, term, what he ran for was, I understand he was pretty adamant about being opposed to Mr. Preston.
Back in 06?
Yeah, 06.
Now, if you succeed for those candidates who succeeded in the primary in June of 2008, do they have any authority to act for the county or for the county council?
Not until they were sworn into office at the January of 2009, I guess that would be.
And do those folks who succeeded in winning the primaries in June of 2008, do they have any authority beyond that of private citizens?
No.
In terms of what they can do for the county?
That's correct. As a matter of fact, that was cited by a chairman at one time during one of our meetings, but we all knew that their terms did not begin until in January, and their terms would not begin until they took the oath of office, which is required, and that would be in January the 9th, 2009. So they were just like anybody on the street, they had opinions, but they had no power.
And in June of 2008, having succeeded in winning the primary, these folks still had to survive the general election, although the way Anderson County is, that seemed pretty likely.
That's correct.
What about the 2008 council? And that's the one I described earlier, the sitting council in 2008. How would you describe its level of support for Mr. Preston in 2008?
Well, it was very strong.
And did you see any danger to Mr. Preston that the 2008 council would do anything to terminate his employment or otherwise breach his contract with the county?
The 2008 council would have been very supportive of Mr. Preston, and I can't imagine that they would have done anything to jeopardize his employment.
After the primary elections were held in June of 2008, did you meet with some of those folks who had won the primaries?
I did.
Would you tell the court about that? Like, who did you meet with? How often? What were you talking about?
Okay. We had meetings, at my office over a period of time. We had weekly meetings, and those people that attended would be me and Ms. Wilson. And the reason that we had, and the people there would be, Mr. Allen would come occasionally, Mr. Dunn would come, and Mr. Moore would come. And we had these meetings at my office on Witness Street for the purpose of looking at what financial information that we had, how the budget was being done, how the money was being spent, who was in charge, what kind of contracts were out there. This new council people most had not been ever elected before to any kind of office, and so what we were doing, we're going through kind of an orientation process. That was my intent, so that whenever these folks got into office in January, that they would hit the ground running, so to speak. That there would not be a gap there, a learning curve gap for this new council coming on. And so we would meet at my office on Sunday afternoon, usually for a couple of hours.
And as part of the orientation idea that you're talking about, is it true that newly, or I guess I should say it this way, folks who appear to be elected as council members incoming, say, so a primary winner in 2008 who's going to take office in 2009, are there ways in which those folks get orientation through the departments of council as well, or departments of the county as well, by meeting with county department heads, things like that?
I think they were interested in getting that information, you know. As to the extent of us being able to get that information was another matter. I know that the atmosphere as far as the administration was concerned was to prevent us from getting information. And that made it difficult, and I guess I really don't know to what extent the newly nominated people were able to get information, but that was one of our purposes, was to say, finance knows this, purchasing people know this, and there were a lot of questions about the finance department, our budget, and also as I recall, our purchasing, county purchasing.
About how many times would you estimate you met over the course of the summer of 2008 with folks who had won the primaries?
I'm saying around 5 times. It could have been more than that, but we also had people that were just interested in government come in and listen to what we had to say and make suggestions as well. It was rather open, you know. And I think Mr. Beckwith attended. Tom Beckwith, he was like a retired accountant. We were trying to get advice and share ideas so that we would be able to make an intelligent judgment about how to run a county that we consider to be pretty much out of control, or as far as information is concerned.
Now, Ms. Floyd and Mr. Wilson had also won primaries in 2008.
That's correct.
So they were going to continue on to council after 2009.
That's correct.
Did you invite Ms. Floyd or Mr. Wilson to these meetings?
Did not invite them because they made it clear that they had great admiration for Mr. Preston. So I did not invite them. If they came, I guess we would have said okay, but I didn't specifically invite those people to come.
Did you talk about Mr. Preston at some of these meetings?
To some degree, as administrator and who was in charge of matters, information, I'm sure that we did.
And generally speaking, what was the concern expressed by the group, if there was a concern expressed, during the course of those meetings?
We didn't know how the money was being spent. We could not get information from, we had, after we got started and we got a kind of an audit report. We located all this money that was being spent, but was not verified. There was no documentation for it. There were credit card expenses to one particular councilman who was a great admirer of Mr. Preston. In 1 month, I think, we were learned that he had spent something like $30,000 or so.
Mr. Hearsay, I mean, with respect to contents of documents that have not been presented inside of court, statement-based, basically referring to a document that its contents aren't even before the court.
First, I think it's not hearsay, he's just explaining something that he learned during the course of his work in 2009, and I was just going to clarify.
I'll overrule the objection.
Mr. Waldrep, the audit you're talking about.
Now, I'm talking about Mr. Bob Daniels' audit reflected undocumented expenditures, which were extravagant, in our judgment, at that time, and it was of great concern to us, along with other matters.
I agree with the objection. The audit is also not before the court. I mean, that's the document that he's referring to. That's not in evidence.
Well, he didn't quote the document. I think he said unauthorized expenditures that total to a certain amount. I haven't heard him yet say anything that he says directly came from the document.
Right.
He said he reviewed it.
Yeah, he was just testifying about the document's contents, that there were unauthorized transactions. If they want to put in an expert report, then they should get the expert on the stand. They should put his report in the right way. They should lay the foundation. They should have the compliance with Rule 7.
I'm going to give you an opportunity to cross-examine him on those points, obviously. And again, I haven't heard him indicate that he's directly quoting from the document. My understanding of the testimony was it was information that he learned during these meetings. One of the documents they reviewed was this audit report from someone, and but I didn't hear him say that he was quoting directly from that document. There could have been other documents, I guess, that were involved in what he was referring to. And you certainly have a right to test the basis of his opinion and determine those things.
I understand.
So my ruling would remain the same. You may proceed.
Thank you, Your Honor. And just to clarify for the court, Mr. Waldrep, what you're talking about in terms of these things you've seen were from a report of Mr. Bob Daniel, but that occurred in 2009, is that right?
I think so. I believe that was the day.
All right, so what I want to do is take you back to 2008 and the meetings you were having with some of these folks who had succeeded in winning their primaries to ask what were the concerns at that point in time. This is before you knew any results of any audit.
It was still the spending issue and the information issue. And if I may, when I was elected chairman, I pretty much ran my campaign on the basis of transparency and clarity and government. I thought that was important. And the first statement that I made upon my election as chairman to the public and to the rest of the council that was my intent was to seek clarity in government. That did not receive a warm look at that time from the administration.
And did some of the primary winners in June of 2008, who you were meeting with, people like Mr. Moore and Mr. Allen and Mr. Dunn, did they seem to share that same view of open government?
They seem to, yes. I think they've continued to do that.
At your meetings with these folks during the summer of 2008, did you ever talk about the possibility of doing an audit of some kind of Anderson County records?
Yes, we did. Yeah, general discussion on that.
Did this group that was meeting on occasion in your office, did it have any authority to act for the county?
Absolutely none.
And to your knowledge, did that group ever make any kind of a plan to fire Mr. Preston after it came to power in January of 2009?
No, the only plan that came up that I recall was we had a workshop at one time, and Mr. Moore had prepared a list of items that were of concern to him, such as purchasing and what have you, that might be an exhibit in this trial, I'm not sure. But that was provided to me at a meeting, I think it was August the 5th, maybe, of that year, 2008. And I shared that letter that came from Mr. Moore with the rest of the 2008 council. And we had a great exchange in there between me and Mr. Wilson, Mr. Ron Wilson, about the idea of an audit and also the idea of putting Mr. Preston on administrative leave, and also the finance director, Ms. Humphreys, on administrative leave, while we did an audit to determine what was the status of the books.
And you were, what were you talking about in terms of an audit? When would such an audit occur, if at all?
Well, that was to be determined, but I think at that particular meeting, I was requesting council, this 2008 council, to wait until we got to the next council, and to defer that action on that. And I think that was agreed, because the prior council, 2008 council, had already prepared an ordinance for an audit, but it was a penny in, penny out audit. And I don't know how familiar you are with auditing. I've continued to learn more, but that would be the most expensive kind of audit that you could possibly have, and it would not be really productive of the information we were looking for. That kind of audit is when you go out and count the nuts and bolts in the transportation department, things of that nature. We were looking for a focused audit that was focused on the main part of the expenditures, So we had a big discussion on that, but having said that, the council, it was a consensus of the 2008 council to wait until 2009 until the new council was seated.
Wait till then to allow the new council to direct whether or not
to direct it. That's correct.
And what the scope of the audit might be?
Beg pardon?
And what the scope of any audit might be?
Yeah, and the scope and timing, and also the person that was going to conduct the audit.
Your Honor, may I approach the witness?
Yes, you may.
Mr. Waldrep.
For an opinion?
No, Your Honor, I'm just asking his personal opinion. He happens to be a lawyer, I'll grant you that.
Certainly, I'm saying, as an attorney, did you form an opinion?
He did frame it as an attorney. I'll let you rephrase
Yes,
the
sir.
question.
Mr. Waldrep, did you form an opinion personally as to the validity of any claim that was set forth in Mr. Hoskins' letter of September 2008?
Qualifying that with my lack of expertise in that particular action, and also qualifying it by the fact that there would be some deference placed to those who practice law in that area as a specialty. I looked upon this letter as baloney.
And the prospective council members who had won primaries back in June, at the point of September of 2008, were they in office yet?
No,
Had the general election even been held at this point?
no, sir.
And after that letter came in, what did the county do, to your knowledge?
Well,
in response?
when this letter came in from Mr. Preston's attorney, our chairman, Mr. Thompson, appointed a committee headed up by, I believe, Mr. Ron Wilson, who might have been the chairman of the Personnel Committee, to investigate the allegations of Mr. Preston as to whether or not there was or was not a breach, and what kind of damages, and where were we, or were we headed down the old litigation path, again. So that was done.
Do you recall who served on the personnel committee
I do.
that addressed the letter of Mr. Hoskins in September of 08?
I do. Mr. Greer, Mr. McBee, and Mr. Wilson.
Do you happen to remember one way or another if that was a standing committee that had already been existing in 2008?
You know, I believe it was a standing committee because we are required as chairman to formulate or form a committee within a particular period of time. I think it's right at the beginning of the term. And if you don't form that committee at that time, then you don't have a right to have committees. You'd have to have ad hoc committees, you know.
Mr. Waldrep, what was your understanding of what the Personnel Committee was charged to do with respect to the claim that Mr. Preston appeared to be making in September of 2008?
They were charged with, I guess, investigating the merits of the claim as to whether or not there was any legal foundation for it, or whether we were to be liable in some way for the breach of the contract.
And did you have any understanding as to whether or not the Personnel Committee was supposed to come back to the council as a whole with any kind of a recommendation?
Yes, sir. That is a practice and procedure that you turn this over to the committee does a study, then they come back and they make a presentation to council, so the council can either accept or reject or ask questions or have discussion on what the Personnel Committee has done, is the reason why they did what they did, you know.
So would it be fair to say that at the time the Personnel Committee was charged with researching and investigating this particular claim, your expectation was that you would receive a recommendation back from that committee at some point?
Yes, sir.
Did the committee hire, or did the county hire, legal counsel to assist the committee in its evaluation of the claim of Mr.
Yes,
Preston?
we had if I can give you a little bit of background into that, I remember us going over to the council members. I don't know if it was everybody there, but I know that there was a number. I know Mr. Floyd was there. I know Mr. McAbee was there. I know, you're right. It might have just been Ms. Floyd, Mr. McAbee, Mr. Greer, Ms. Wilson, and I. When they had a meeting, I always tried to go to some of these committee meetings.
Narrative, Your Honor?
Yes, sir.
I mean, this is a question and answer mode of interrogation.
I think he's gotten away from the question that you asked.
I'll give him a better question.
Why don't you give him another?
And the question, Mr. Waldrep, was, this was an easy question, did they hire counsel? Either the Personnel Committee or did the county council hire counsel?
Well, it did, and
tell us.
I just wanted to explain how that process.
And that was my next question. Can you tell us how that process occurred? Were you involved in it? How many lawyers were interviewed? That kind of thing.
There were 3 lawyers that were proposed, and I can't remember the names of the other 2, but I particularly remember Mr. Bright's name.
Is that Tom Bright?
Tom Bright,
Do you
right.
remember what firm he's from?
Ogletree firm.
And so Tom Bright from Ogletree and a couple other law firms were
That's
considered.
correct. That I understood practice law, and we met in the side room beside the main room that we have at the courthouse. It was kind of a call meeting, I guess you might say, of that meeting.
And let me understand that basically it sounds like the council itself evaluated 3 different law firms and ultimately hired.
No, it's a
right?
committee
Okay,
itself.
committee.
Now, I chirped in, although I was not on the committee, because I was interested in who would be the interpreter of Mr. Hoskins' letter. And when I saw that Mr. McAbee and Mr. Greer and Ms. Floyd, and I'm trying to think about her being in there too. Anyway, and they were very anxious for Mr. Bright to be the attorney. That made me uncomfortable, you know. But nevertheless, they had the votes to get it done.
And Mr. Bright was ultimately
Yeah,
hired.
and so he was selected.
And to your knowledge, is Mr. Bright an employment lawyer?
Yes.
And And as I understand it, Mr. Bright was charged with helping the Personnel Committee evaluate Mr. Preston.
That's correct.
Did the Personnel Committee actually meet at some point to discuss the claim?
They did.
How did that happen? Did you
Well,
attend?
it's interesting the way it happened was that I did not get a notice myself that they were going to have a personnel meeting. Normally, we have our personnel meetings in the city in Anderson at the courthouse, you know. But I found out at the last minute that they were having this personnel meeting in Powdersville at the library up there, Mr. Wilson's district in Powdersville, which is around 20 miles away. And Miss Wilson and she found out too, and we were able to make it to the meeting in Powdersville.
Did you have the impression that the meeting was set in Powdersville for a reason that far away?
I felt like maybe I wasn't welcome.
And what happened when you got to the meeting in Powdersville, the meeting of the Personnel Committee?
They immediately decided that they would go into, quote, executive session. There's 3 of them would go into executive session. And they decided that neither I nor Ms. Wilson would be able to go in. I pulled a section of the code out, the statute that we operate under, which says, in effect, the county council members are encouraged to be in attendance of committee meetings. And so finally, they let me attend, but it was a lot of noise about it, and I knew that they didn't really want me in there, but it felt like maybe that they had to let me in, so I was able to attend.
And what happened when you attended that Personnel Committee meeting? What was discussed?
Well, I particularly remember Mr. Wilson, who didn't want me in there anyway, speaking to Mr. Bright and encouraging Mr. Bright to find justification for Mr. Hoskins' position. And it was when Mr. Bright did not agree that Mr. Hoskins' letter had real merit to it, the atmosphere became a little bit charged and irritated on the committee that Mr. Bright had come up with a decision which obviously they found displeasing.
And before that meeting had occurred, were you aware that Mr. Bright interviewed the various council members about Mr. Preston's claim, just as a general matter?
I wasn't sure that he had talked to everybody. I know I talked to him a couple of times.
And what was your assessment of the general advice Mr. Bright was giving to the Personnel Committee at the meeting that you attended?
Well, I guess, kind of felt pleased that my humble common sense opinion with a limited experience in that area coincided with Mr. Bright's opinion that this matter had little merit to it.
What happened after that first meeting? Did the Personnel Committee meet again?
They did, and this time I tried to attend. It was at the courthouse, and I tried to attend the meeting, but I was told that I could not enter this time, that they'd done more research and they found out that executive sessions, they could still exclude me from executive session, and they had, park police deputies up there, and I decided that discretion was a better part of valor, and I did not try to break into the meeting or anything, so they had their meeting alone in the executive session.
Were you the only county council member who wanted to attend that second meeting of the Personnel Committee and did not?
I think Ms. Wilson wanted to attend also.
Did Ms. Wilson attend the first Personnel Committee meeting?
Yes, she did, as I recall.
Do you recall how long that first meeting took, roughly?
We must have been in from there. well, maybe a little more than a half an hour or so. And that was, the first thing that I recall was the amount that Mr. Hoskins had demanded, I think, in his letter about how much money he wanted. I don't know, well, I'm not sure whether it's in the...
I think that comes in a subsequent letter, Mr. Waldrep, just to help you.
I didn't see it. Go ahead.
That comes in a subsequent letter, the amount.
Okay, all right, okay. Anyway, there was a tremendous sum, over $1 million, that Mr. Bright talked about as a demand, and he felt like that we were not liable for that sum.
Did you ever hear back from the Personnel Committee with any sort of recommendation as to how, if at all, to respond to the Preston claim?
No, we never heard about it.
What is the next you heard about Mr. Preston's claim after that second Personnel Committee meeting that you were not allowed to attend?
November the 18th of 2000. Let's see, that would be 2008.
I'll show you.
2012.
That's right. Let me show you, Mr. Waldrep, if I may. May I approach you?
Why don't we take a short break? I think we're getting ready to go into the meeting where the
Yes, sir.
agreement was approved. Rather than break that up, we've been going for about 2 hours.
Of the severance agreement and release. All in favor of the severance agreement and release of claims, please vote. 4, 5, opposed, abstained. How do you guys vote?
I'm voting against this. This is still a railroad job, and we're lacking our fiduciary.
Ms. Wilson, you don't have the floor. I'm just asking how you vote.
Y'all don't have good sense.
Mr. Chair, are you through with that? No, ma'am. I'm still trying to get my vote here. The vote is 5-1, and Mr. Waldrep abstained. So it's 5-1-1. It passes again.
Okay, Mr. Chairman.
Ms. Floyd.
Mr. Chairman, in form of a motion, I think that I want to make a motion that we at this time hire our new administrator, and I would like to put in the motion that we hire Michael Cunningham. I have contracts available.
Mr. Chairman, I second. Okay.
Yeah. You need a motion?
Your Honor, if I may continue the question.
Yes, sir.
Mr. Waldrep, can you describe for us how you felt as that meeting on November 18th, 2008 took place?
Objection. Well, what is how he feels make a difference in this case.
I think it's relevant, Your Honor, state of mind. It shows what was happening at the time.
I'm going to ask you to rephrase it. I'm not sure.
Let me just-
Feelings are one thing.
Let me ask it this way then.
All right, please do.
Words.
Thank
Mr. Waldrep, can you describe for us how the meeting took place in your view in terms of the procedures that were followed?
John, well, cumulative, we didn't just watch the exact thing he's about to testify.
Well, I'm going to allow him to state how he felt the meeting went forward. I'll let him go ahead and do that.
I was, first of all, I was shocked and surprised. I'd never seen a public body act in that way before without notice to the public or notice to the body itself. They were taking that action, and I was, of course, greatly disappointed and shocked.
Were there other meetings, regularly scheduled Anderson County Council meetings that were on the calendar that would occur between that November 18th meeting and the end of the calendar year?
Yes, there were meetings. That meeting was in November. I think we had a couple of meetings, maybe 3. I'm not sure that we could have had notice of such a contract, and there was at least a couple of meetings in December, as I recall. We usually have their scheduled meetings.
Was there any reason that you could see why this issue of Mr. Preston's severance agreement had to be conducted at this meeting without being placed on the agenda?
No, I couldn't understand why unless there was a tactical reason for Mr. Preston's attorney to accelerate this process and to get it done in a fashion that's the only reason I could think of.
I move to strike that.
I'll sustain the objection, strike that response as to what tactics the attorney may have had in his mind.
I'm going to move on to a different question, Mr. Waldrep. Was Mr. Preston present at that meeting that we just observed?
Yes, he was.
Did you ever see him leave the meeting?
I don't recall him seeing him leave the meeting. He might have moved his chair or something. I think when Mr. Cunningham was appointed.
Had you been given any indication that the agenda for that meeting was going to be amended to discuss the topics of both Mr. Preston's severance agreement and the hiring of Mr. Cunningham?
None whatsoever.
At some point, the severance agreement for Mr. Preston was in fact passed out at the meeting, correct?
Was it,
At some point, the severance agreement, which I believe you have in front of you still, Mr.
Yeah.
Waldrep, Exhibit 7, was that passed out at the meeting at some point?
I believe it was, so yes.
Had you ever seen that severance agreement prior to the November 18, 2008 meeting?
No, sir.
Did you have time to study it sufficiently to be in a position to vote on it that night?
No, sir. Didn't.
Did you observe whether other council members present at the meeting actually took the time to read the document when it was passed out?
I didn't notice that they had. It appeared to me that they had read it sometime before they got to the meeting.
What type of substantive debate did you have about the severance agreement at that meeting?
What type of?
Substantive debate about the content.
Well, I had a lot of questions about, first of all, whether it was justified. Secondly, whether or not the amounts that were put in were appropriate. And that concerned me.
All right. It was non-responsive. I mean, he's not even answering the questions that are being asked at this point.
I will ask the witness to be responsive. You may proceed.
Mr. Waldrep, listen to the question if you would. My question was, what type of substantive debate, if any, was held during that meeting
I'm sorry.
about the severance agreement?
I didn't know of any. I couldn't see of any debate. The argument seemed to be about whether the procedure, whether we should even be looking at this agreement at that time.
And at the same meeting, November 18, 2008, of County Council, would you agree that we saw a document passed out that showed a proposed transfer of county funds that would be used to pay for the severance agreement for Mr. Preston?
Yes, that's all that.
If I may approach, Your Honor.
You may.
I'm going to hand you what's been marked as Claims Exhibit number 8, which has been pre-admitted. Is that the document, Mr. Waldrep, that was passed out at the November 18, 2008 meeting concerning the transfers?
Yes, I see it. I mean, this is what they presented. But that was the first time I'd seen it.
Were there motions to reconsider that were made at that meeting?
Yes, there were.
What did you make of that?
Well, council had gotten sort of sophisticated, I think, in parliamentary procedure to the extent that they realized that the people that were kind of running the show that night, that if they made a motion for reconsideration, and that would cut off any further opportunity for council to meet at a separate time, subsequent time, to change their decision on the contract.
The final vote that we saw, Mr. Waldrep, on the reconsideration of Mr. Preston's severance agreement was a vote that was 5-1 with you abstaining. Why did you abstain from that last vote?
Well, things were moving along, I think, at a pretty rapid clip. I was trying to factor in what the strategy was that they were using to cut off debate. I don't know if I was thinking exactly clearly when I made that, what the implications were going to be with regard to reconsideration or non-reconsideration. And because I just didn't feel comfortable with the whole thing, I disapproved of everything, I just decided I wouldn't vote on that issue.
And at some point, we saw Ms. Floyd handed out a proposed contract to hire Mr. Cunningham as the new county administrator. Do you remember that?
That's correct.
And may I approach one last time, Your Honor?
You may.
So I'm going to show you Mr. Waldrep has been pre-admitted as financial exhibit number 9. Is that the proposed master employment agreement that was handed out by Ms. Floyd to hire Mr. Cunningham as the new county administrator?
Yes, this is what was handed out.
Had you seen that document before the November 18, 2008 meeting?
No, sir, I had not seen this document. I was just checking the dates on this document here. I think it appears to be dated 19th of November, 2008.
So the day after the meeting?
Yes.
Is that still the document that was actually passed out?
That appears to be the document that was passed around.
It appears to you, though, that when looking at it, it was actually signed or executed on the next day. Is that right?
Yes.
Did it surprise you that Ms. Floyd had that contract already prepared and in her hand for this meeting?
Well, yeah, it surprised me. She just pulled it out of her pocketbook. She had several copies and pulled it out of her pocketbook.
We just watched the video that she did not pull out.
Well, the videotape speaks for itself, and of course you can cross-examine the witness as to the extent of his recollection. Videotape is in evidence, so I'll probably take a look at it for a third or fourth time before I do this case. You may proceed.
Mr. Waldrep, were any inquiries made of you as to how you might vote on a severance agreement for Mr. Preston before this meeting happened?
Was there any?
Anybody asked you how you might vote on a severance agreement before the meeting?
Before? No.
Did council ever consider the remaining items that were left on the agenda after it voted on the contract to employ Mr. Cunningham that night?
They did not.
I'm going to show you now, if you don't mind putting Exhibit 7 in front of you, which is the severance agreement for Mr. Preston.
Okay,
Tell
let me
me
see
what
if
it
I've got them all. Yeah, okay.
If you look at the severance agreement, and if you turn to Section 4 of the severance agreement,
Right.
are you there? I'm also going to show it on the screen. How much did the severance agreement provide for in payments to or for the benefit of Mr. Preston?
Well, it was a total of $1,139,833 plus a 2006 Yukon vehicle.
Okay, and how much of the $1,139,833 figure was attributed to the value of the severance provision of Mr. Preston's master employment agreement?
Looks like it's 700. It's the severance benefit.
Right.
Oh, it looks like it's $780,575.
And how much of that severance, total severance payout to or on Mr. Preston's behalf was attributed to the value of the county purchasing retirement service credit on Mr. Preston's behalf?
It appears to be $359,258.
Did you think those payments were justified to Mr. Preston?
No, sir.
Did you ever hear any explanation as to the legal basis that would justify the payment of those amounts?
Not really. We had no debate on that, no figures to look at or to determine or to compare to anything else. And so these were, it seemed like pretty much the same figures that Mr. Hoskins had asked for.
Your Honor, I don't have any further questions from Mr. Waldrep. Would you like me to retrieve those exhibits for the clerk or leave them with him?
Are those the actual exhibits?
Yes, sir.
Yes, you might want, well, you might go and give them back. I don't know what Mr. Davis wants to get into.
I'll send those back into order.
All right. Are you all right? Hope there's no
Well,
charge, hope there's no
they always
extra
say.
charge for that. Okay,
Thank you, Your Honor. That's all I have.
yes, sir. Glad you're okay. Davis, you may proceed.
Your Honor, I could only hope to be half as cat-like as my opposing counsel.
I don't recommend the lawyer to do that very often. You may proceed.
Mr. Waldrep, I'd like to back up just for a minute and go back to a little bit about your background. You've been practicing law since 1968?
64.
1964?
That's correct.
You were on Anderson County Council in 1990?
I was on county council in 1990, 91, something in that era.
You went to the Senate,
Yeah,
served there 12 years.
I did.
You returned to county council somewhere in the 06 timeframe.
Yeah, that's correct.
Served for another 4 years.
No, not a full term. I served a term and then I served about 3/4 of a term because I had to resign and to be trustee at South Carolina State University.
You started in 06, right?
I think so.
And you ended in 2010, according to your testimony on direct.
I think so.
You served District 1.
I did.
This lawsuit was filed in 2009, correct?
I guess it is, whatever the record shows.
You were on county council in 2009, right?
Yes, I was. I was for a while until I resigned.
While you were on county council, it's true, is it not, that you became familiar with the Anderson County Code provisions that relate to when council members can and cannot vote in relation to financial interests that they may have?
I think so, yeah.
You know those provisions, right?
I think so, too.
And then there's another provision in the Anderson County Code that relates to ethics as pertaining to confidential information. You know that provision too, don't you?
Well, yeah, generally.
Now, Your Honor, if you don't mind, I'd like to approach. I think I have a way that we may be able to accelerate.
You may approach the witness.
And Your Honor, if I may approach you as well, I have a binder too. And what this binder is, Your Honor, is it's the exhibits that I'm going to ask some questions about. And what I hoped was that by virtue of our flipping through them in the order I'm going to ask, it would help the court, it would help the witness, and it would help opposing counsel just stay on the same page and move more quickly.
You may proceed.
Under the tab that is Defendant's Exhibit 119, Mr. Waldrep, is this Anderson County Code Provision Section 2-37?
I see.
And what I'd like to turn your attention to, sir,
I see Muni Code up there. I didn't know whether this was specifically labeled for Anderson County. But,
well, let me turn your attention to page 4. Can you look at the paragraph that's numbered 4? Does that paragraph state in part, and I quote, "When members may not vote, no member shall vote on any matter in which she has a personal or financial interest greater than that of the general Anderson County public, or in which she is otherwise disqualified by any state or county law or regulation," end quote.
right.
I read that correctly, right?
I see that.
Can you turn to the next? Tab, which is Defendants 120.
Right.
Mr. Waldrep, is this the Anderson County Code, Section 2-288?
I see that.
And underneath Section A2, it says disclosure of confidential information. Do you see that?
Yes.
And does that provision state, and I quote, "No official or employee shall, without proper legal authorization, disclose confidential information concerning property, government, or affairs of the county, nor shall he use such information to advance the financial or other private interests of himself or others," end quote?
Yes.
Now, Mr. Waldrep, I'd like to turn your attention to somewhat of a different topic. If you could look at Defense Exhibit 136.
Your Honor, this is one of the ones we object to, this exhibit. We object based on hearsay and I
Yes, it's sought to introduce it, so it's not before me. Technically, are you going there?
I'm going to introduce this exhibit into the record, Your Honor.
All right, then maybe we'll address it right now. And I'll get ahead of ourselves.
Yes, sir.
Yes, sir.
I think it may be a little bit premature, because I think if I ask a couple questions.
Well, I'm gonna let him ask his foundation questions, and when the time comes, you have the right to make your objection. Yes, sir, Member C.
Mr. Waldrep, you were on county council as of February 7th, 2008, were you not?
Yes, I think so.
And if you look at Defense Exhibit 136, it reflects a carbon copy down the bottom. Do you see that?
Yes.
And it reflects all council members received this letter, does it not?
Yes.
And you received this letter in February 2008, didn't you?
Mr. Davis, if I did receive this, I don't recall it. I may have received it because we got an awful lot of mail.
Mr. Waldrep, do you recall an instance back in February of 2008 where County Council Chairman Michael Thompson related to the council that he was experiencing harassment from members of the community?
You know, I really don't. That to me doesn't register at all that he won.
And Mr. Waldrep, you also don't recall instances where all the other council members, except for perhaps you, Ms. Wilson, received threatening letters threatening sodomization of those council members, do you?
Objection, Your Honor. This is hearsay. what the other council
Just one
members.
second, Mr. Walter. I'm trying to answer the question. He's trying to put in an objection. Thank you, sir.
What,
Yes, sir.
what council members may have said about harassing letters they may have received is, first of all, hearsay, because they're not here to say it. And second of all, the harassing letter content is further hearsay, one step removed, because it's an anonymous letter from who knows whom. So I don't think this is a fruitful area of inquiry. This objection.
Number one, that wasn't the question I asked him. I asked him, did he remember during this time frame whether there were council members who were complaining of receiving threatening letters wherein such things as sodomization were being threatened? Now, he was on county council at that time. If it seems like to me that if somebody got a letter or heard about a threat like that, that would be the type of threat someone might remember. And so I'm asking him, does he recall that?
And one other objection would be relevant.
Well, he's not asking it, I don't think, for the truth of the matter asserted. I think he's asking whether he had heard of that and what his state of mind might have been. I think that's where you're going. Had he heard those things? I'm going to overrule the objection if he has a recollection. Maybe that becomes objectionable at some point in time, but we'll see whether he's heard of that or not. Go ahead, Mr. Davis. I'm going to ask the question. It's on cross-examination.
Mr. Waldrep, do you recall an instance in the beginning of 2008 where it was reported to the entirety of county council that the other council members were actually receiving anonymous, threatening letters at their home?
The only thing I can remember is that there was an atmosphere of counter threats, of people getting letters that were supposed to be investigated by SLED. I remember that much, Mr. Davis. But as to a particular letter going to someone on council, I don't. I really don't.
Fair enough. Let's move on. Mr. Waldrep, I'd like to turn your attention to the 2008 primary. You were asked some questions about the 2008 primary on direct. Remember that?
Yeah.
If I recall correctly, the 2008 primary and I guess all primaries occur in June. Is that right?
Yeah, I believe so. Sometimes they, other times, but as I recall, that was in June.
In June of 2008, Tom Allen ran against Bill McAdoo for District 4.
Right.
Tom Allen won.
Right.
In June of 2008, Eddie Moore ran against Larry Greer in District 3.
Right.
Eddie Moore won.
Right.
In 2008, Tommy Dunn ran against Michael Thompson.
Correct.
Tommy Dunn won. All right?
Well, and he did after, he didn't really win. Actually, what happened was that I think he got less votes than that were necessary for him to prevail. And then there was another process that continued on where I think Mr. Thompson withdrew or in some way, and ultimately Mr. Dunn was declared the winner. That's what I, for some reason.
In June of 2008, Tommy Dunn and Michael Thompson ran into a runoff.
Right.
And then Mr. Thompson dropped out.
Right.
Tommy Dunn won.
Ultimately.
And in June of 2008, you ran against Raymond McKay.
He ran against me.
Right. Raymond, that is a fair point. Raymond McKay, he ran against you in June of 2008. Right?
Right.
And you and Mr. McKay got into a runoff.
Right. Mr. Brooks Brown ran also.
And Brooks Brown, when he was the third vote getter, he endorsed you, right?
Ultimately, he did.
And then you got into the runoff with Mr. McKay.
That's correct.
And you won.
I did.
And you won sometime on or about June 24th, 2008.
I think the runoff was 2 weeks or something after the regular time. That probably coincided.
In a very short time frame after you won on June 24th of 2008, you had a victory party.
I did.
That victory party occurred somewhere around the July 4th of 2008 time frame. Did it not?
I think so. I think so.
It would have happened after June 24th, right?
Yeah, I wouldn't have been celebrating before I won.
And it would have happened in a fairly short period of time after you won on June 24th. On June 24th of 2008, you told the Anderson Independent Mail, and I quote, "It's not often you get the chance to run against a candidate and an administrator." End
Right.
quote. You said that,
I
right?
did. I believe I did. It sounded like something I'd say.
You don't deny that.
No.
Between June of 2008 and December 31st of 2008, that's the time frame when you started having meetings in your office, right?
That sounds about right.
And for the next series of questions, I'm going to talk to you about that time period, okay?
Okay.
You had meetings at your law office, right?
I did.
You had them on Sundays.
I did. After church.
You had them after the primary, right? In June. You invited Tommy Dunn.
I did.
You invited Tom Allen.
I did.
You invited Cindy Wilson.
I did.
You obviously were there too. That's a yes.
Eddie Moore.
Eddie Moore was there. That's right. You at one point you invited Bob Daniel to come, didn't you?
Yes, I think we did.
And at one point there were attorneys from the Nexon Pruitt law firm that attended some of those meetings. Did you not? Were there not?
I have to think about that one. I don't remember. I really don't remember. Now, we had Kurt Gibson come in.
Kurt Gibson was there.
Yeah, Kurt Gibson. And we had Tom Beckwith there.
Tom Beckwith was there.
Mhm.
You testified on direct that these were very open and inclusive meetings, did you not?
Yeah, as far kind of good government meetings, I thought they were.
Open and inclusive meetings for people who thought exactly like you, right?
Not exactly. That's what we were trying to determine.
And for example, Gracie Floyd, she's a Democrat, right?
She,
You didn't invite her.
I haven't invited Miss Floyd anywhere.
And Ron Wilson, he was a Republican, right?
Right. Mhm.
You didn't invite him.
No, I didn't.
Mr. Waldrep, during those meetings, it's true, is it not, that you discussed a number of things.
That's very true.
One thing that you talked about was the services of the McNair law firm, right?
Possibly, yes.
And you also discussed during those meetings the potential hiring of Nexon Pruitt, did you not?
We may have, yes.
And in fact, at one point, you actually met with a member of the law firm of Nexon Pruitt.
I did.
And we had a motions hearing in this case about that, didn't we?
About hiring.
About your meeting with the Nexon Pruitt lawyer, right?
Yeah,
And you submitted an affidavit, did you not?
I may have.
And during that meeting, and in your affidavit, the county took a position that it was partly privileged because you were talking to Nexon Pruitt about the potential of hiring them for the county, right?
Right.
You discussed with folks at your meeting, at your law office, the prospect of hiring a financial investigator. Did you not?
A financial.
Investigator. An auditor.
Oh, yes, yes.
Yeah, whatever.
Oh, yeah, yeah, well, somebody, an auditor.
You talked about that at length.
We did.
After county council changed in January of 2009, in the very first meeting, the county hired Nexon Pruitt. Did it not?
I believe they did.
In the very first meeting, the county hired Bob Daniel. Did they not?
They did.
And during your meetings in your office between June of 08 and 12/31 of 08, you had conversations about certain employees, didn't you?
Conversation with whom? But
You had conversations about certain employees, didn't you?
with whom? I mean, you
The
talk-
group in your
The group.
office.
At that time, I'm sure we had various employees talk conversations about employees and Bob Daniels, attorneys, and we did all that.
Do you deny having talked about Heather Jones?
When?
During the meetings in your office between June of 2008 and 12/31/08, did you deny having spoke with the group about Heather Jones?
Objection. At this point, Your Honor, I just want to clarify one thing. I think it's not relevant to the issues before the court, what may have happened after the severance agreement was signed, November 18, 2008, till December 31, 2008. I think it's an important distinction, and if there are questions about the time frame before the severance agreement, that's one thing. We think questions about what may have happened after the severance agreement is now over is not relevant.
Your Honor, there is a material time frame at work here, and there is a systematic pattern that we're talking about, and that time period runs from June of 2008 and what they were doing all along, and then when it came to fruition in January of 2009, what they're going to come in here and tell you is, oh, we didn't have any authority. We didn't have any authority. We couldn't do anything. What you're going to hear systematically, maybe from this witness, maybe you won't, maybe tonight, but you'll hear over the next couple days, is that chapter, line, and verse. They sat there. They planned what they were going to do. They had the majority of votes. And on January 1st, 2009, as the meeting minutes reflect, they did exactly what they planned. Say one thing, Joey Preston. Because the outgoing county council stopped them in their tracks before they could do that. And so I'm asking the question about that. I don't understand what the objection even is.
It's a pretty simple objection. What they were predicted to do by Mr. Preston, which is the basis of this entire claim, right? Is he said there's an anticipatory breach that has happened because this group of people who is meeting is going to do something to me after January 2009. Whatever it was that they were going to do to him, he resolved that on November 18, 2008, when he signed off on his severance agreement. So what they might have done after that has no bearing whatsoever on Mr. Preston's concern about what they might do because he's now gone.
You may proceed.
Mr. Waldrep, we were talking about Heather Jones, remember that? Between June of 2008 and December 31st of 2008, do you deny that the group that met at your office was discussing Heather Jones?
I'm trying to think, Mr. Davis. We discussed all employees. She may have been discussed, but to what degree, I'm somewhat honestly somewhat doubtful because we had such a large agenda. Heather Jones was not the purpose of those meetings. The purpose of those meetings was something else. Incidentally, her name could have been mentioned because she was, I think she was economic director or something of that nature.
Question's actually much simpler than that. Do you deny that the group had conversations about Heather Jones?
Are you saying me personally? Or are you saying,
Are you saying anybody else in the
group?
witness stand, sir?
Yeah, if you're saying that I did or did not, I don't really remember. I just don't.
So you don't deny it?
Well, I can't if I don't remember, Mr. Davis. I really don't recall.
Do you deny that the group that met in your office between June of 2008 and December 31st of 2008 had specific conversations about Gina Humphreys?
No. We had, because she was a finance director, and so we had specific conversations. I feel sure about her. But Heather Jones, she was kind of way away from the thrust of what we were trying to do, and that was to get our hands on the financial information.
You don't remember Heather Jones being discussed, right?
I don't.
Michelle Ricketson? Did you have conversations about Michelle Ricketson?
Michelle Ricketson. Probably.
Bill Sterling. You know who Bill Sterling is?
Oh, yeah.
You had conversations about him, right?
Yeah, we did. Because that was a necessity of the park police, and I think he headed up the park police.
During your meetings between June 2008 and December of 2008, you discussed who's going to be the next county council chairman, did you not?
Probably.
You even just...
Didn't come, but I don't think he was there.
It's a different question than what I asked you. Did you become aware at some point in time that Mr. Preston was asked not to attend
No.
the August 5th of 2008? You deny that?
I deny that. But as far as I know, I can't. And the reason I say that is because I can't imagine any circumstance where we wouldn't want to have the public administrator there. But
Mr. Waldrep, if you don't mind, will you turn to page 13 of Plaintiff's Exhibit 2?
13
Yes, sir.
of the Exhibit 2.
Yes, sir. Mr. Waldrep, can I get you some water while we're approaching?
You may.
No, I'll get.
Good. I'll be back.
Okay.
I think you must be getting low.
Number 13. Okay.
Mr. Waldrep, these ideas were not fundamentally your ideas, were they?
Fundamentally, I shared a lot of the ideas with
Yeah.
with Mr. Moore's assessment, because Mr. Moore had talked with some of the incoming council members and we talked about it.
Mr. Waldrep, these weren't extemporaneous remarks, were they?
On page 13.
Page
is that what you're
13.
talking about what I'm saying?
Page 13 reflects the remarks that you gave to the audit committee on August 5th of 2008, does it not?
Mr. Davis, on that day, I had in my hand a letter of some kind from Mr. Moore. I may have amplified some things that Mr. Moore said. I may have editorialized a little bit on what Mr. Moore said, but it was a combination of probably some things that I approved of as well as Mr. Moore. So as to the authorship of this, I would say we would have to share to some degree credit for authoring the ideas that come forth on page 13.
You have to share credit for the ideas on page 13, is that right?
Yes, right.
Well, are you denying then that the ideas on page 13, Plaintiff's Exhibit 2, are the same 8 ideas that appeared on Defense Exhibit 52, page 2?
Well, hadn't had time to put them down side by side,
Well, we just went through them, remember that?
but they're very similar.
They're the same, aren't they?
Yeah, very similar.
And those same ideas, they came from Eddie Moore, didn't they?
Well, as to being identical, no, but very similar,
Those were fundamentally Eddie Moore's ideas, weren't they?
generally.
Fundamental.
Well, you select the words you like.
And
I just, we're just bandying and parsing words here, but I'm just trying to give you what I recall as being the general idea that both of us had talked to one another. He had sent me these ideas. I presented them to council at that workshop meeting.
And do you deny that when I asked you the same exact question during your deposition, when you were under the same exact sworn oath that you are under here today, and under the same penalty of perjury during your deposition, your response was that they were extemporaneous remarks?
They were.
They were.
They were. They were. They were. Let me try to answer that question. You have.
Your Honor, we have a witness in the court.
Mr. Bright, we asked a question of the witness.
What I was doing was taking Mr. Moore's letter, and I didn't prepare any remarks myself, any personal remarks, and I think that was one of the big disputes that we had. And I tried to go back to, I think it's page 65 in my deposition.
Oh, you remember that one, do you?
I did, because she kept asking me that same question.
And I asked you, are these ideas fundamentally your ideas? And you said, yes, they were fundamentally your ideas. Did you not?
No, I don't deny that, but I think what your question was directed at was you prepared remarks. You prepared something. That I prepared this. I was speaking extemporaneously pretty much based on what these ideas were, and they were similar. That's why I went back to try to give you an explanation. I think it was on page 65 in the deposition. And if you look at that answer in the deposition, you'll find that that's exactly what I did.
Well, let's keep going and see what else we can see, okay?
Well, let's take our break for lunch right now, and I'll let you get back on that. Come back, Davis.
Yes,
All right, I'll caution the witness not to discuss his testimony during the break. You may step down at this time. We will resume, let's say, about 1:15. Court's in recess, not 1:15, 2:15.
Thank you very much.
Done.